Good morning, everyone. Thanks for coming on this. Can everyone hear me clear, by the way? Yeah. All right. Thanks for coming on this final day of CPDP. I hope everyone's doing well and not too hungover from the party yesterday. My name is Freddy Konjale. I work for the Dutch DPA in a team that focuses on GDPR supervision of algorithms. And I want to start by explaining why I'm organizing this panel. Because I think it's a super important topic, but I feel like not enough people are talking about it, and I want to get more people to talk about it. So I think it's fair to say that the use of biometrics has become normalized. We use it to unlock our phones, our laptops, to make payments, whatever. And there's been a large focus on facial recognition and fingerprinting, and rightfully so. But then in the last few years, we've seen the adaptation of soft biometrics. And unlike traditional biometrics like facial recognition, soft biometrics often lack the distinctiveness to identify individuals, but are used to categorize people on either physical or behavioral traits. But importantly, it's still about our bodies. And I think this raises some questions about data protection, regulation, fundamental rights, but also just what we consider to be biometric data. And so increasingly, we see soft biometrics being used in both public and private spaces, usually to detect incidents like theft, violence, or any other unwanted activities. And at the Dutch DPA, we've seen a few different use cases. So if we could go to the next slide. Yeah, so we've seen it being used in supermarkets to detect for theft. Then also public transport, where it's being used to detect for violence or safety-related things. But then also in elderly care to detect if someone has fallen. And while soft biometrics is a broad field, because it can also include accent detection, which is being used at the EU borders, emotion recognition or keystroke dynamics, I'd like to focus on behavioral analysis in this panel, which is basically when a CCTV camera is being equipped with software to monitor our behavior. But it's been quite difficult to tackle this phenomenon because the GDPR seems to be lacking regarding the regulation of soft biometrics. And so in this panel, we'll go into a few different use cases and how the current legal regime applies to soft biometrics, and we'll also try to make a connection to fundamental rights. Welcome. And just to be extra clear, we're not talking about facial recognition here, but soft biometrics. And so to discuss this, I've invited Catherine Josserand from the University of Groningen, where she researches the intersection between AI, biometrics, and fundamental rights. Then Bilge Soussumer, who's a researcher at KU Leuven's Center for IT and IP Law, and she specialized in EU data laws with a focus on biometrics as well. Then Oyidia Oji, she works at the European Network Against Racism as a digital rights advocate who's worked on the resistance and appropriation of technology with a focus on people from underrepresented backgrounds. And then finally, Stefan Kulk, my colleague from the Dutch DPA. He works in the coordination of algorithms department, and he focuses on the implementation of the AI Act. And when you take the floor, you can also take a few minutes to talk about your work a bit more. So Catherine, I want to start with you. Could you explain from a technical perspective how soft biometrics work, and also what sets them apart from traditional biometrics like facial recognition?
Yes. Thank you very much, Ferdi. Good morning, everyone. Thank you for organizing.
You can also
maybe.
use this.
Yes, maybe. Thank you for organizing this panel. It's very interesting, actually, to talk about soft biometrics because, from a technical perspective, it doesn't have a specific meaning in the sense that they used to describe, for example, let's take facial images. It will be used to label these facial images and describe physical characteristics, to describe as well what the person wears, to describe the skin tone, different elements. So first it was used only at descriptive elements, and then researchers found out that they could improve the biometric system, so identification system or verification system, thanks to this additional information. So that's how it developed. And afterwards, they developed that they were able to use it for what we call continuous user authentication or verification, meaning that, for example, if you open your smartphone, you can use your face to open your smartphone, but you can also use a pattern. So instead of a password, you will use a pattern, and this continuous user authentication will actually record the pattern and see if it's the same pattern. But what we talk about here, it's not necessarily about using these soft biometrics to confirm your identity, because this will be the case, but it's more generic categories of information that can be used, and they are not specific to one person, but they could be specific to a group of people as well. So I think there are different topics here. It's also interesting to note that we have an ISO IEC standard on biometric vocabulary, does not define these soft biometrics. However, Anil Jain is one of the experts in the United States in fingerprints, but in general in biometrics from a technical approach, described these soft biometrics as a set of traits providing information about a user without individually authenticating the subject due to their lack of distinctiveness and permanence. And I think that's exactly what you said. These two characteristics make a difference with the use of traditional biometric traits, such as facial geometry, the reach of your fingerprint, and different information that can link this information to a specific individual. Either use it for identification, meaning that you try to find out if a person is known in any database, or for verification purposes, just to confirm the identity and to get access, for example, to premises. So it's very interesting because we have seen an evolution, and if you think of the French law to secure the Olympic Games and other large events, it was adopted in 2023. This is based on behavioral biometrics. So it's not to find out what a specific individual is doing, but what a crowd might do, and to intervene. But it's still somehow biometrics. But it's not biometrics the way we understand it under the GDPR, and we will keep that for later. I think there's definitely a distinction to have. What is the purpose of use of these soft biometrics? Is it still to identify someone, to single out? When we say identify, we have to understand single out someone. Or is it more to categorize people in categories, well, in different categories that are common to people? So I say skin colors, it could be ethnicity, and that's where we might have also other issues.
Thank you. Oidi, I want to move to you. Given that these technologies usually are not specific enough to identify an individual, but can say something about a group, I was wondering if you've seen cases like this in your work at ENAR, and what do you see to be the most urgent risks coming from this technology?
Well, I think Catherine already gave a very good example with the Olympic Games in France, because when you think where these technologies were deployed, if you use a heat map, you will see that many of those areas were neighborhoods in which there were people racialized already there. And so in the end, the goal of the government was to detect crowds, to make sure that in terms of making sure that the Olympic Games were secure for everyone, they were surveying groups of people. So then for me, it is more about what's the intention of the government, who's supposed to be safe and who's supposed to feel unsafe by the deployment of those technologies put in those neighborhoods. And And at the same time, like who they are trying to target, right? And which kind of criminalities is it? Because at the same time, this is an example in the Olympic Games of Paris, but also before in Rio de Janeiro, it was already still deployed the same, more or less the same kind of technologies. And nowadays, I mean, Rio de Janeiro was in 2016, it's 2025, and those technologies are still there. So what kind of security we are looking for? Was it for a specific moment of I mean, 3 months? Because that's what the duration of the Olympic Games usually it is for. Or is it, in the end, like it has a way more like a long-term thought or objective to surveil certain kind of areas, right? So in the end, there's this balance in which safety is not the same for everyone. The definition of safety depends on who you're talking to. And sometimes by making safe certain kind of people, usually white people, you are making unsafe marginalized communities who have been historically being surveilled. So at the same time, when we think about biometrics, I think usually should be like a very neutral point of view, like a biological point of view. But in the end, it's making, like, it derives to a more social construction of what it is permitted and what is not, right? So I think that linking it to security, linking it as well to the criminalization of migrants or people who are perceived as migrants, because in many cases they are also targeting EU citizens, right? It is something that is very dangerous. And and I think it is, there's this point in which that we should try to think what we are missing when we are trying, I mean, what technology is trying to cover and what are the needs that in the end communities or our society needs that we are putting or that we're trying to cover with technology. Because it's really problematic when we think that technology can solve many of our societal problems that maybe we don't want to talk about. By covering technology, just by putting technology there, just by spending money, because in the end it's like a long-term process that little by little has been like more expanded with since COVID-19. We're trying not to talk about the problems that our society has, and putting budgets, like increasing budgets for the deployment of these technologies. So I think there should be a way in which more conversation should be, or more spaces should be given to marginalized communities in this case, or people who might be at some point affected. Because first it starts, I don't know, with migrants, after it starts with, people from the LGBTQ community, and in the end it affects all of us. So it's like a little waves, let's say, of how the technology starts affecting certain kinds of groups, and how in the end all of us, we are getting involved.
And then, do you feel we should make a distinction between its use in like public spaces for safety, and then the example of like a semi-public space, but it's like a private company, a supermarket implementing this technology?
Well, I think it's problematic in both ways, right? Because in the end, you are trying to provide those kind of services. Like, you should be able to go to a supermarket, for example, and just buy. But but there's people who go to a supermarket and they have to behave in a completely different way as they would be normally behaving. And that's a problem, because you're not being you. And still, by modifying the way you move, for example, you're still being targeted. Yeah. So there's a problem there, like at its essence. And when I think about the deployment of technologies in public spaces, sometimes for example, if I see some works in a square, my second question is, are they going to only, like, I don't know, put it beautiful, or are they going to install cameras to make sure that there's people who are not welcome in these places, right? So there's also like those kind of barriers in which you know that there's people who are not welcomed.
Yeah, thank you. So I think it's fair to say that, this technology is a bit problematic, maybe. I want to move into the legal and regulatory challenges, because, well, soft biometrics seem to fall into this like legal gray zone. And Bilkasu, I want to ask you, what do you think makes it that soft biometrics like fall into this like gray area?
Yeah, thank you. So I can highlight maybe 4 crucial legal gaps. There are more, but these are the most, I think, pressing ones and why they matter. So the first of all, the categorization of soft biometrics is problematic because we always talk about facial recognition, fingerprint, and these hard biometrics. And these are covered by the GDPR, although there are also discussions about that because of the definition of biometric data. And as we know, there may be the most protective article in the GDPR is Article 9 that covers special categories of personal data. And it mentions biometric data, but it has like 5 components, of course, personal data resulting from specific technical processing and allowing or confirming unique identification of a person. So soft biometrics do not really meet this criteria. So that's one of the reasons that it's not categorized under Article 9, and they are not then provided the, heightened protection. What is the problem here? Of course, age, gender, skin tone, body shape, clothing styles, they are not covered by this definition, and they are functionally sensitive, of course. And I found very interesting when I first started to work on biometrics, that some scholars say that location data can be also regarded as soft biometrics, because if you track a person, for example, their house, their work, and like where they go, like usually, you can actually create a very unique map of this person's life. So it's actually unique to that person. And it is not under Article 9. Although it's very risky. So the gray zone here, that AI systems especially categorize people based on this functionally sensitive and visible, because it's easily captured, specifically the video appliances are, of course, problematic here. And, this does not trigger the GDPR's most protective safeguards. First of all, this is, in my opinion, this is a regulatory blind spot. And I started my PhD in a project called Privacy Matters, and I was one of the 2 legal scholars working with computer scientists. And there I saw that a lot of new developments are coming using soft biometrics to enhance, as Catherine said, like enhance, refine, or support hard biometrics. Because hard biometrics themselves they don't provide the necessary accuracy. So these are usually, for example, walking patterns of a person, or eye tracking, or keystrokes, or mouse movements can be used to accurately identify a person. And as you can guess, there are many privacy issues that are not covered by the GDPR. The second one is about the definition of personal data itself. So it's a bit of a contextualization of identifiability under the GDPR. I'm not going to go so deep into this because probably for the last 3 days you heard a lot about how personal data is very problematic and we cannot define it. And usually data controllers say that they don't process personal data because they pseudonymize it. And in this context, this is very crucial because most times they just, for example, process young, female, 20s, short. So this information alone, it can affect how this person is treated in a, of course it's contextual, but specific environment. So it can affect like what ads, for example, they see. So it functions like identification in practice, but without any accountability. So one example that wasn't, I think, there in the slides that I want to mention, that maybe the criminal investigations can also use soft biometrics. For example, wounds of a person in a criminal investigation, and this should be also like freshly taking pictures, etc., because it changes dynamically very fast. So this is, for example, soft biometric data. Of course, when it is, and in most cases, it is attached to persons' personal data, other personal data, and so if there's additional personal data, of course, this also identifies as personal data. But what we see in practice, most controllers, they try to separate those, maybe under another company, or they use only statistics, so they claim that they anonymize it. So there are a lot of fragmented bits, so we shouldn't see hard biometrics and soft biometrics only in isolation. Because hard biometrics in themselves have a lot of soft biometrics in them. So this is also very problematic because it is not so different than hard biometrics, but the treatment is totally different. And I will mention two more legal gaps very briefly. One is the overuse of course, legitimate interest. And in this case, because it's not covered under, like, by Article 9, so the security is used, marketing, customer insights, mainly for AI development, product development is used as a base for legitimate interest. And especially for web scraping, it is almost impossible to isolate sensitive data from regular data. So the reality, this is becoming like a catch-all or like a joker card kind of legal basis. And no proper balancing tests, without awareness of people, without or minimal transparency. And the last point is that the Article 22, the right not to be subject to automated decision making. So this has a condition called significant legal effects. And for example, in the case I mentioned, the young female, short, 20, so there are significant effects, of course, in a specific context, but these usually are not regarded under Article 22. And this article, unlike Article 9, is not introducing a default prohibition. So that's also in scholarship identified as one of the problems, because it gives a right, but yeah, it can be invoked later, and so it is not a prohibition that the controller should always keep in mind even before the processing. So yeah, these are the main four categories that are, I think, the most pressing. But of course, there are a lot of issues. For example, as I said, like web scraping, data minimization, storage limitation. So that's, I think, as much, like many data and technologies right now in effect, I think GDPR is challenged more and more. So
yeah. Thank you. And I want to get back to a point you made about anonymous data a bit later. But first, I'd like to ask Stefan, what does the AI Act say about soft biometrics? And I know you also did a call for input about emotion recognition. And I'm wondering, what people said about like this definition of biometric data.
Sure. Yeah. Hi, everyone. Maybe a brief introduction. I'm Stefan Cook. I work at the Dutch Data Protection Authority, where we are, of course, working on GDPR supervision. But I'm more involved with the AI Act and also the preparatory work that we do there. Just to make sure we are not yet appointed as a market surveillance authority. This will take some time. I wonder by the time that if we are appointed, if there's still an AI Act left, but that we have to see how that plays out in the upcoming months and years. But yes, so under the AI Act, I think what's interesting is that you see biometric data and biometric AI systems are regulated as well. And of course, the most significant one, the most significant use case is probably the biometric identification, so the camera, face recognition systems. But also, you have this prohibition on emotion recognition, and emotion recognition is also in certain cases it's a high risk AI system. So, if you look at the prohibition on emotion recognition, you cannot use these systems in school settings or at the workplace. I think, that prohibition in itself provides some sort of, I think, a good avenues also to regulate some of the uses that we've been talking about in the panel today. As we are preparing also for a task as a market surveillance authority, we are also looking into these prohibitions. And we want to understand them, and we also want to know how people who are in the private sector or government organizations, we want to know how they view these prohibitions as well and what their questions are. So what we did is we organized a couple of calls for input where we asked the people from academia, private sector, everyone who has somehow an interest in the AI Act to raise their questions about this prohibition, and in particular prohibition on emotion recognition. And I think what became very clear is that there are still a lot of questions to be answered here. So what is an emotion in the first place? As a male lawyer, I can relate to that question very. What is emotion? But also in a legal sense. So what is? So that's a difficult question. But also, what is biometric data? And then you see in the AI Act that there's a definition of biometric data in there as well, that more or less copies the GDPR provision. But also says that sort of from the part that is about uniquely identifying a person is taken out of that. So that sort of broadens the scope of biometric data under the AI Act, which makes it, I think, a very enhanced or broadened the scope of what is biometric data, and then also how the AI Act regulates biometric data. Of course, biometric data under the AI Act are still personal data. So I think you run into some issues that Bilgesu mentioned as well. If you can somehow argue that there's no personal data in play anymore, I think you'll run into issues under the AI Act as well. So yeah, I think that, emotion recognition, the prohibition is very relevant under the AI Act, but I think one of the I guess nice things about the AI Act is that it's not so much focused on data and processing, and it's about certain use cases of AI systems, of which some are prohibited and some are high risk. And I think if you look at some of the high risk cases, so if you use AI for law enforcement, or in HR, then systems can be high risk. And then the question whether or not biometric data is involved is not really a legal question. So I think also in the high risk cases, they have a great potential also, I think, to regulate AI applications where biometric data or soft biometrics are used. And now what I find interesting, though, is that if you look at the high-risk cases currently in the AI Act and the system that you had on the screen before, so the systems used in public transport or in the shops, those are not high-risk cases. So there's maybe some work to be done here in the future because I can see the risk, but they're under the AI Act, they're not yet high-risk cases. So I see a lot of potential under the AI Act, also as a prospective supervisory authority here. But the AI Act doesn't solve, there's still a lot of questions around how does it apply, and I think we'll be in discussions about it in the next few months and years. But in particular with respect to what is high risk, I think there's still some work to be done to tackle some of the issues that the speakers have mentioned already. Yeah.
Thank you. So I want to go back to the notion of these systems using or not using personal data and whether or not they're anonymous. Because can we get the slide back on, please? Because on the picture on the left, you can see it pretty clearly. I think vendors often claim that these systems are anonymous because they're only looking at like broad patterns and like whether your arm is moving or not. But then I wonder, if you then use this to intervene and then walk up to someone, can this still be considered to be anonymous, or are you then doing identification? Is there anyone who would like to respond to that?
I can. Yeah, it's actually a great point, because this is usually how it is used, like to just try to implement some like privacy enhancing techniques. And what I see is that even the controllers that use these techniques, like it is called privacy enhancing techniques, but they still claim that they don't process personal data after implementing this. So it's a bit confusing because, yeah, well, you're obliged to do something about privacy, you accept that, but you don't process personal data. So yeah, you don't fall under the scope of the GDPR. So the main problem here is, I think that identifiability as a concept, I think maybe is not enough anymore. And this was also discussed a lot in the scholarship in the recent years. Especially there's a very interesting article of Nadia Portova, but not the law of everything. That is the most popular one in 2022. So she argued that identifiability should cover also the targeting people. But of course, this is very valuable contribution. But it doesn't inherently, I think, target group privacy. So maybe it might be the concept to look at here to, yeah, maybe AI Act is also more actually useful in that sense. But this information can be used to target not only this person here, but also to other people. So like, I think we should focus on the consequences when it comes to identifiability, or we should just move beyond the GDPR and look for, yeah, other, I don't know, frameworks, which is very complicated also because yeah, every day there is a new regulation coming up. But I think we need a rigorous mapping of things and how these interplay with each other, and then, yeah, spot more legal gaps probably.
Is there anyone else who would like to add to this? I think you.
Yeah, and then I will make the link to the other topic. I think if you think of behavioral biometrics, you can definitely use them to single out, and that's what we use, single out someone. If you think of gait, it's possible to know who the person is with a different level of accuracy, because sometimes two people, they might look like each other when they walk. But you could think as well of these behavioral biometrics just to analyze what people do, but not single out. Like you want to sell a product and you target a group age. You target women. We know that it has already been done. So in that case, it's a group. It will be more a group profiling that's singling out. And I think it's very important for our discussion that we distinguish that. You are talking about the elderly case, person that falls. You could have two things. So you could have our gait that is analyzed, and then just the fact that this person fell. And it has nothing to do with the singling out that person. But if you have the gait or if you have other information, you can know who fell. So I think I say this because what I believe is that we have many different cases, and it's very difficult to get one overview of it. I also agree with the comment made by Stéphane. I think we don't have a generic category of high risk, and sometimes this is really missing, because if your case doesn't fall under any of the broad category of use cases, it's not high risk. And then it means that it's not regulated. If it doesn't fall under transparency risk, then it's not regulated. And I think we will see that in the future, is that the way the AI Act was designed, I can be critical, we can all be critical, criticizing the AI Act. It's good that we have some red line. But at the same time, these use cases, they are based on some kind of past AI incidents, like historic data, I would say, when it was drafted, and then it might not be future-proof. So that's one of the problems that I have. And I know that you wanted me to talk about whether the legal regime is sufficient. So I will go back a little bit to the GDPR, because I think this is very important. If you use soft biometrics to, in the end, single out someone, and you use some sensitive attributes like ethnicity, then you could think that, yes, it's not biometric data as defined in the GDPR, but it could still be sensitive data. And I think this is very important. And that's what the AI Act actually recognizes under this biometric categorization systems. With the broader definition of biometric data, it's all confusing, because if you process biometric data, you don't know if they are biometric personal data or if they are just biometric data according to the AI Act. So this is confusing. We have now these two definitions. But this categorization, this biometric categorization system, it's also to recognize that you can have some issues when you are processing sensitive attributes. And it's not about single out someone, but it's about focusing on a group of people, on categorization, people that share the same characteristics. So under the AI Act, you have this. A part of it will be, of course, prohibited, but then the rest is high risk. Then you have emotional recognition, as Stefan explained. On emotion, I personally have an issue, is because it's recognized in a recital of the GDP of the AI Act that the expression of emotion is not universal, and we don't have really a scientific basis for that, you know, to do emotional recognition. But due to that, only 2 fields are excluded, or 2 sectors. And then the one that could be, but that I think it's also problematic, is the use of emotional recognition in the context of law enforcement, of border control management. The use of the lie detector, the polygraph, is not considered as a prohibited practice. So we have on one side this lack of scientific basis, and on the other side, still this possibility under high-risk systems. And what is also confusing for scientists, I want to maybe to mention that, is that scientists, they come to us, computer scientists, and they say, we are developing lie detectors or polygraphs. They don't say lie detector, they say polygraph. Can you back up the scientific study under the AI Act? I'm like, we are not backing up any science under the AI Act. The legal regime is also relying on the state of the art. So, but this will be used actually to detect some emotion, lie, if we can detect lie. So you see that you have different elements. And then beyond biometrics, you have also profiling. You have so crime prediction. You can have as well the subliminal techniques that are used to influence someone. So that's why it's very difficult to have a broad overview. I think it's more thinking of, okay, we have these different cases, even if we know that this approach is not the best, but you have these different use cases. Which kind of risk do they trigger, and which kind of tools do we have? And then we have also the Charter of Fundamental Rights, the right to not be subjected to discrimination. And there is also a directive on equal treatment, irrespective of racial and ethnic origin. And I think this is very important. So it's difficult to have a broad overview, but I think at some point it's important, and we write about that, and in collaboration with DPAs.
Can I? Just to add, because I can. There's one thing that I found quite strange in the AI Act. Indeed, is that in the recital they said that there's no scientific basis indeed for emotion recognition, and I find it very hard to explain that. Then in some cases it's prohibited because of a power imbalance, apparently, and in other cases. Oh, you have systems that are in different settings can be used regardless of the lack of the scientific basis. So there's a strange sort of loop in there. But so that's a very good point that I agree with. Something that I wanted to add is also that with respect to the AI Act, even if it is a high risk case, and if we add high risk cases. Now, the nice thing I think about the AI Act is that there's some room. It's made regulated in a flexible way, in the sense that the European Commission, it's in an annex, so the European Commission can add these systems relatively quickly. We don't need to go through a full legislative process again. So there's so if you're focusing on very specific use cases, then you also need this flexibility, and it's in there, and I think we should really make use of that. And I think we also have a role as authorities to keep sort of monitoring the use, and to also highlight or signal that there are systems in place that we think should also be high risk. And I think the science academics have a role to play there as well. Now, one thing, maybe final point about the AI Act, that even if something is high risk, if you go back to the AI Act and what it is intending to do, it's not really trying to sort of regulate actual individual use cases. It's about making sure that there are safe systems on the market. So if you have a system that can be used for a particular use case, there's all kinds of rules and in the future standards that you'll need to adhere to, and then you put your product on the market. But then, the AI Act is not so much about actual use cases and how it is actually employed. So that's not what the AI Act intended to do, I think. It's sort of taking one step back in the value chain and also creating responsibilities, in particular for developers. So I'm just, the AI Act in that sense can also not solve all the issues, I think, here, because of this product safety approach that is in there.
Can I just quickly add on that? Yeah, it was very interesting. So that one thing that is actually in the AI Act that is related to this, it's actually about hard biometrics, that one of the prohibited use cases is, and there are no exemptions, and I found very interesting, that untargeted facial image scraping online. So I think that was super important. It's very a good move. But at the same time, it might have an effect maybe on this soft biometrics because, well, if it's only facial images, then soft biometrics can still be scraped in an untargeted way. And for the other prohibitions and high-risk categories, there are a lot of exemptions. And one of them is about biometric verification systems. And as we know, soft biometrics are used in the verification context most often. And, well, AI explicitly excludes biometric verification from, it's out of the scope. So that's, I think, one of the concerns also about soft biometrics, but also about other biometric categories, because they are used in combination to verify people. And verification is usually one-to-one context and not one-to-n, like searching the database, like identification. But at the same time, the lines are very blurry, so that a company or a system easily can be designed to search a person, and when you look at the technical documents, you also see that verification can also be done one-to-n to find that one person, but not really doing a search. So, these things are, I think, still not much. There, as you said, like there are a lot actually to add and maybe interpret, if possible, in the AI Act. But some things are like really explicitly excluded. So I also can't see that like how to interpret. In a favoring individuals way or fundamental rights friendly way.
Thank you. I want to move a bit away from the GDPR and AI Act, and just to kind of set the scene. In theory, every camera can be equipped with this technology, and I think this has the potential to change camera surveillance, CCTV surveillance as we know it. And so I'm wondering if, to tackle this problem, is data protection even the right approach, or maybe should we focus on fundamental rights more, like the right to human dignity? And Oidi, I was wondering, how do you see this connection between soft biometrics and like a more fundamental rights-based approach?
Well, I think when we are talking about how to regulate in digital spaces, I see that fundamental rights are one of the least things in which our legislators are thinking of. And I think it has like a really clear direction towards this idea of securitization of Europe, right? And how do we make sure that we have a society that feels secure in our terms, and it doesn't matter if we are infringing certain people's fundamental rights, right? So I think, having this kind of framework, it's really, I think it should not be negotiable to have fundamental rights on the table, right? Because without that, like, what kind of Europe are we trying to portray, right? Like, and after how, like, understanding that the EU serves as an example to other places, to other territories, right? And at the same time thinking like the competitiveness of the EU, right? Like there's a moment in which they are trying to compete with other spaces. Why not competing on human rights, right? Nowadays they are trying to compete by removing, by deregulating, for example, the GDPR, trying to make a lower move with the AI Act. Why not saying, hey, we are going to put fundamental rights on top of everything? And then from there, we will start to talk and to see how GDPR can be improved, maybe to make sure that personal data is really being taken into account, regardless of where you're coming from and who you are, regardless if you have papers or not, because also like this kind of thought of, it's only, in the end, it has been, it was modified, right? Like it's not, GDPR, it's not only for citizens, so it's for personas in the end, right? So I think there's this need of removing by trying to make sure that the industry can be happy, can still be on the forefront of economical growth, let's say. But yeah, and there's a specific push from the private sector to give us this need of using technology, right? When in the end, we should try to see in which other ways we can still have our society in which there's still like fundamental rights put in place, and maybe thinking about care as a method of going forward. Understanding as well that our legal frameworks, let's be honest, like they are never going to be ahead of our times, because it's impossible. I mean, at least from now, it's impossible. Maybe in the future it will be something better, right? So understanding that legal frameworks cannot be at the forefront, we should try to be creative in ways of tackling our own problems, in ways in which most probably legislations will not be able to back us, right? But it doesn't mean that need is still there and that should be covered somehow. And yeah, in this case, by trying to, and specifically when, for example, we are seeing that the AI Act, for example, is enhancing the use of technologies on certain kind of environments, such as law enforcement and migration, without any impunity. Like, who is going to police the police, for example? Who is going to make sure that those agencies are going to be protecting the fundamental rights of those of people on the move, for example, or racialized people or any other marginalized community? It's very difficult to of course, tackle these questions, but I think we should try to move forward at the same time as a society to have those spaces in which different people who are not interested in the AI Act, but who might be affected or have any kind of relationship with the AI Act, could be private sector, could be think tanks. I mean, there's a lot of, I think everyone, right? It's in the end has a kind of link with the AI Act. That should be those spaces like created for them so that they can have like a better, like a more holistic approach of how technology should be used.
Thank you. Is there anyone who would like to respond to this? Catherine?
Yes. I don't know if it's only human dignity, but human dignity, it's about your autonomy and agency. And I think this is very important, even especially if you think of emotion or thought. Well, you could link actually human dignity and freedom of thought as well. The question is that we have, these fundamental rights. How are they interpreted and applied? It should be the starting point, because these fundamental rights are always cited in the recitals of these instruments. But it's more that it seems that in reality we move forward, we move aside from the application, or you need a specific case law for an interpretation. So the question is that, do we rely on what we have? And wait for interpretation to include some of the most problematic, I would say, soft biometrics cases? Or do we need to create something new? And in some countries, you have, for example, discussion about neural rights inscribed in the constitution. So is it enough what we have? That's also my question. It's more an open question, because I don't have the answer to that. I think we have never thought about soft biometrics maybe so deep, because you don't see that much academic work or literature on this, on the term of soft biometrics. But I think it's time that we make a list of the different issues and look at what is available, and I think make distinction between the different cases.
Oh, yeah? Okay, great. So, yeah, I see actually a very strong connection between biometrics, soft biometrics, and human dignity, but like every biometric characteristic, because it's bodily information, and there are discussions that is it a violation of bodily integrity? Maybe it's too far, but I also see, these are of course protected by the Charter and then the European Convention of Human Rights and autonomy as well. But what GDPR is doing is to actually bringing to the more exercisable, more enforceable level for people. And who is doing that? Of course, the controller as the gatekeeper. So I think GDPR is, of course, as a starting point, great, but if you're trying to go back and how we can actually try to enforce these fundamental rights, this is a great starting point to understand if the law works or not, and apparently it doesn't. And I want to give, for example, one example about mental autonomy. So, a couple of years ago, China has experimented with brain monitoring technology in schools, and to track students' concentration levels. So how we concentrate, how we focus on something is actually producing a soft biometric data if you don't identify the person directly, but if only focus on the signal that the brain is producing at that moment is called P300. And this is a prime example for soft biometrics because let's say if I have a headset, and this apparently happened in this case, the educational set, and a teacher can see that if I'm 100% focused or how much of percentage I'm focusing right now. And of course, and this happened in many schools with the parents' consent. So when we say consent is the most strong and the way to go, it also shows that maybe it's not, because we're talking about pupils here. And so for emotion recognition is the same, but I think there are a lot of things to discover about this soft biometrics that will probably become problematic in the future, especially in the context of neurodata, because this is it is the next big thing probably in soft biometrics. And now China doesn't use this app anymore because of the backlash, but I think we will have different versions, because this technology is also used for example, ADHD treatment, for neurofeedback. And many kids are now diagnosed with that. So I think we will use more often this kind of technologies.
Thank you. So I think it's clear that more needs to happen. And I'm wondering how you guys think about can we create a coalition of counterforce, and what roles do you see DPAs playing in this?
I think you can actually lead this coalition. It depends also on your role, if you work as only data protection authority, or if you are advising as well on these AI system issues, because it's not only about data protection. But I think you could organize a workshop and invite different experts from different fields, so technical experts as well. Companies, because you need to understand how they use these systems. It's very important to have NGOs involved and academics. But it will be important to, as I said, to distinguish these cases again, if it's something that is used to single out someone or not, and the impact on the person as well, and the group or the group. And I will also leave the others answer this question, because I think it's very important that we get your views on that.
I think to add to the list, I would put as well equality bodies under the Article 77. It's really important that they are there. As they could potentially be a connection between affected people, affected communities, and the market surveillance authorities. Yep, I think it's super important, as well, like how we could try as well, maybe at some point, like add communities affected or potentially affected, because in the end it would be, I don't know, maybe half of the population, right, who could be affected at some point, or even more. So yeah, it's in the end we should also try to think, how do we approach all those groups? Should they be in the same room all together? Or are there specific topics that should be discussed separately, depending on their interest on how they can approach the problem? Because of course, the problem can be, I mean, some people are more solution oriented, but other people have, I don't know, they can dream more widely on how to tackle the problem, right? So yeah, how to make sure that every group is welcomed in the same way. And try to foster participation, right? Participation is key in this kind of processes, and yeah. So I think making sure that everyone is there, trying to provide spaces where we should also think like who should be there, who should not be there at certain kind of moments, and of course have like full transparency with the whole group at some point, right? Like to make sure that everyone is there, but at the same time is okay. We are going to have this discussion, and after the discussion, what happens next, right? Because usually when we are trying to gather as many, for example, for when we are trying to make this kind of conversations, for example, with marginalized communities, in many ways it's very extractive. And in a way that after the follow-up steps are never communicated, or they never know what happened with the information or their insights that they provided, right? So I think it's really important to have them like to drive the group in a way that everyone can stay, that from the beginning until the end, they can be really well informed about the different developments.
Yeah. Thank you for that. That's a great point. I think we have 15 more minutes, right?
Make a short
Yeah.
point. Yeah. So because it's, I think, yeah, you also asked the question about that. What can data protection authorities, of course, do here? And so we, in our role as a coordinating AI and algorithm authority in the Netherlands, we are also monitoring sort of developments in the Netherlands with respect to what the risks and opportunities are also of AI and algorithm use in a very broad sense, of course. So you may have seen that we've published reports also on the use of chat apps for self-help purposes. And this is, I think, something that, that's maybe not typical for a data protection authority to do. And here we also look sort of beyond the GDPR, and we consider fundamental rights and public values in a broad sense. So here we also we are setting up a sort of a monitoring function that can inform also the work that is done in policy, but also Dutch society. And where we also we try to reach out to academics, NGOs, and we set up workshops and things like that. We are also did sort of a call for input on biometric. So it's something I think maybe that also sort of I think the supervisory authorities of the future also really need. I think we, as data protection authorities, I think it's we are there because of the charter. As we look at data protection and processing, we need to consider also fundamental rights, and I think also starting monitoring and setting up systems for that, and also gathering that input is something that we already do, and that we're working on a lot. And I think it's something that that is we're still working on as authorities, but I think it's good that you mentioned that as well, and we're very open to that as well.
Yeah, and I think not just us as a DPA, but all DPAs in general, I think could do more to include different groups in this. I do want to also take some time to get some questions from the crowd. I see one in the back there.
Fantastic event, thank you very much. So, okay, my name is Mario Guglielmetti, I work for the DPAs, but it's an academic event, so I speak academic viewpoint. First of all, the AI Act, does it protect enough? We have to open our eyes. Sorry, it's just two considerations. We have concrete examples. In Hungary, for example, the law on facial recognition at gay pride events. So this can be out of AI Act provision, either because it's about ex post, so basically the recordings are showed after, or because it's administrative offense. So there is a reaction from civil society, DPAs, and so on. And the key words in this is being catalyst. If you're not a catalyst of these efforts, I think we will fail. And second consideration, GDPR is not enough if considered as nitty-gritty with the controller, with the processor, and so on and so forth, and legal basis. We have to go behind and look at Articles 7 and 8 of the Charter of Fundamental Rights and Privacy. Otherwise, the issue is there. The Commissioner spokesperson said it's not prohibited, facial recognition at the gay pride in these two occasions, but fortunately we have DPAs. But if DPAs don't look at 7 and 8, the situation stays as it is. And of course, all these technologies, as you know better, can trigger very stable digital autocracy. So when they are put in place in countries which already have a problem, the situation organically gets worse. It's Hungary now, could be somewhere else. Finally, second consideration, because otherwise we have too many things to say, is about the examples you made about the supermarket and shoplifting. This is also to show possible flaws of the AI Act. I'm not sure that this case falls under one of the Annex 3 use cases, because it's not emotion, it's not identification. So basically this technology, which is very impacting, imagine a person who has a disability, trembles, takes the object, put it back, falls on the ground, and so on and so forth. Not speaking about proportionality, and the fact that all these things, in order to work, need the camera, the CCTV, is not that they come out of the blue. And also, the business case. Would you enter a shop which has all these things in place? So at the end, you gain something from some shoplifting, but maybe people prefer not to enter this which gives some anxiety, this kind of shop monitored like that. So again, we have to look at 7 and 8, the other articles. Fortunately, DPAs are now also, especially now, fundamental rights agency more broadly. Very, very final suggestion to read the reanimation of pseudoscience is an article by Mel Andrews, Birban, I don't know how to pronounce it, and it's super, super great. So it shows that the soft biometrics at the end can be the hardest ones. Thank you.
Thank you. I'm not completely sure if I heard a question in there, but is there anyone who'd like to respond to this?
No, yeah, and I left my academic hat, I put it to the side a couple of years ago. So I'm here, as, of course, in a role as a data protection capacity, but I do really feel that data protection authorities, it's very important that we also go back to our roots. Our roots are ultimately also in the Charter, right? Of course, we were the GDPR, but we have our sort of our role is also in the Charter. We are also ultimately, I think, protectors of fundamental rights, and we need to also get that in our more sort of technical GDPR supervision. Yeah, I think that is challenging also in these times where we as data protection authorities and the GDPR itself is under fire a bit. But I see your point.
Maybe I can add something. I totally agree with you. When I mentioned earlier use cases, actually in this high-risk annex, it was not to say they are use cases. They are broad category. But if it doesn't fall in any of these categories, you don't have another provision that will say if a system complies with certain criteria, it could be high risk. And that's the problem. Well, you have safety components, of course, so that's another way to classify as high risk. But it seems that it was based on, as I say, on existing incidents that we could identify, and some were unacceptable from fundamental rights perspective, and they are prohibited, with some exception depending which ones, and the others, they were high risk. But what the Commission also presented a long time ago is that most of the AI system will not be regulated. In one of the documents that they wrote, it was written that. So if we didn't think of this soft biometrics at that time when it was negotiated, we have to look at where it could fit, but it's all a question of interpretation. And as academics, we don't have any binding interpretative authority. You don't as well, except when you make a decision that is binding. But we don't. So we have to wait for the European Court of Justice to decide on this. So I think that's why there is a problem. And if we rely only on fundamental rights, I mean, it's very important to rely on fundamental rights, but we need a court case. And without that, in this gray zone that we are, a lot of systems can be developed and they can affect people. It's true that all these rules of the AI Act, they have to comply with, because they are they constitute interference with fundamental rights, and that's the starting point. They have to comply with necessity and proportionality, and they need a legal basis, but still, it's interpretation. And the court is not going to interpret every single case. So I really see a problem here, and that's why you have a role, I think, in providing guidance. The EDPS as well, I think. The CNIL, for example, I wanted to cite the work that the CNIL did on voice assistant. They published a white paper on voice assistant in 2020. I think there is room to publish a white paper on this topic, and to bring it up, this topic. It will be easier. Otherwise, we will need to wait for one case, and then it will take many years before we have an interpretation by the court on a specific case.
Thank you.
There is no other question. Can I also add to that?
Are there other questions? Go to that first.
No.
Thank you so much. It was a great panel. I'm from Istanbul University, so I'm an academic. But I wanted to ask actually something that I have recently been asked also. It's about customer satisfaction and the AI technologies used for this purpose. So sometimes it's not just the text, but it's the voice recording itself, which has been transferred and analyzed. And the scale can be a satisfaction scale from 1 to 10 or something else, but it can be more also detailed analysis regarding the somehow emotional state of the customer, angry, happy, disappointed, and even more detailed. I do wonder, would it be regarded as soft biometrics or under AI Act, under GDPR? And in this sense, do you also think that Article 9 is actually narrowing down the categorization of biometric data compared to the definition of biometric data under GDPR, Article 4? Also, I think there's when there is an alternative option to achieve the same aim for the data minimization principle, the data controllers should go there, and I think data protection authorities are really strict about this generally in Europe, especially when you use hard biometric data. So you can, even with the option of consent, it's generally not allowed. This is what we are actually going to discuss in the afternoon, the academic session 3, so a little bit of advertisement. Why wouldn't it be possible to actually take the fundamental rights into this question? Because I think data minimization principle, aim and means, proportionality is not just an assessment of cost-benefit analysis. It has to take into account the fundamental rights. I don't think there is any obstacle to interpret the law in such a way.
Who wants to have a go?
Okay. So, yeah, I can start with the voice recording itself. Is definitely even hard biometric characteristics. But again, here, like, why is this used in this context? Like, uniquely identifying a person, confirming or allowing. So, like in the past, there was a confusion about like this cover verification and identification together. Now with the guidance, we have an answer, but of course it's not legally binding, and I hope it will be more like it will be applied by the controllers. But for the emotional state derived from the voice recording, of course it can be done lawfully, but the question is it soft biometric, or because it's derived from the hard biometrics, maybe it is also considered that it is identified already, so that it is related to an identified person in that context, because that person has an account. So is it a bank, for example, and so they already identified the person, and then they are adding this biometric data in their profile, depending on how they keep the data. So I think it's a very interesting question, and then it can be interpreted differently, but in my opinion, because the person is already identified, this is helping the identification, but the main purpose here is the customer satisfaction. And so again, like if you go to AI Act, I don't see that there is any category that we can, like, is it high risk? I don't think so. Emotional recognition, but there are also exemptions.
Yeah, I think you can ask the question: is it prohibited or not? And I don't think so, because it's prohibited in the workspace. But this is not in a sort of in this relationship of employer-employee, or so it's. So I would say it is high risk, but that I think so. Yeah.
But I agree with Bilgesu. My first question was why do you need the voice recording? Because I think, why do you need the voice recording? I think it's because it saves time, right? Or it might be for, we know that when we interact with the call centers, they record very often to analyze afterwards, customer satisfaction. But will it be another way to do it? Because you have all these recordings that are not necessary for that purpose. And then if you have them, what is the guarantee that they are not used for other purposes, including research on the voice and research on customer satisfaction? So from the position of the customer, the question is always, what is the necessity? Or is it really,
And in that sense, you're very right. I think that the fundamental rights play a very big role, but also the proportionality test. It is something quite vague in many contexts, and people tend to ignore many things. And I don't think the main focus right now, unfortunately, as Oidia said, that is not the fundamental rights anymore. But it's very, it's very saddening. But so hopefully this will change. But I think this is also about politics and everything. But how the regulation will take like a more maybe strong posture, and how the EU will say things about it, because we're not going to now, I think, the fundamental rights direction. So the balance is a little bit tilted towards the innovation everywhere in the world.
Something very brief as well, like in terms of efficiency of the model, I know personally that like voice tonality is not the same. Like depending culturally, it's completely different, and I don't think that they will take into account that when they are trying to analyze like the voice and try to, I don't know, predict their customer, like their satisfaction towards the product, right? So yeah, it's also something that I guess like the companies are not thinking about it when they are trying to see, like, I mean, it could be that it would be interesting that they say, okay, what kind of customers we have? And from there, like, is it necessary, and how efficient it could be that we positively are able to really get to the goal that we want, which is to understand if they are satisfied or not, right?
All right, so we have 2 more minutes. If there's anyone with a very short question, and please do keep it short.
Thank you so much for this amazing panel. I work at the Data Protection Authority, and to be honest, sometimes it can feel a bit hopeless because you're bound to these same legal instruments that, you know, the GDPR is not future-proof, the AI Act is risk-based, not right-based, it fails migrants, it fails marginalized people. So I really feel like it's more market-driven, and my question is, do you feel like, what are we doing wrong? Because I feel like that it is mainly the private sector that is leading these conversations. Is it because we're not sitting at these tables? Is it because we are not getting space to be seated at these tables? And if you would be regulators for one day, what is like the concrete advice or like one thing that you would tell us to do in this limited capacity that we have, because we're also bound to these legal instruments that provide a lot of gray zone?
Oidia, do you want to answer this?
It's very difficult to answer this because we don't have a lot. But I can think, for example, of an example of the deployment of, I mean, there was an idea in Spain to deploy cameras to also like to detect how happy or sad passengers were at train stations. And for example, that was published in the newspapers. And then the reaction of the society was so high, saying, why the company wants to know how happy or how bad we are going to our home or going to our workplaces. And after that, after 2 or 3 days, the company said, the national company said, well, we are sorry, this was a mistake, we are not going to deploy it. So I think we should start to realize the power that we have as a society to change things without regulation, because in many cases these kind of technologies are deployed, and after the questions come after, because we are not involved even in the in the first point of the idea, right? But if I was a DPA from the DPA for a day, I don't know, I think I would suffer as well.
That would be too short one day, right? I think that would be too short one day, but I think it's a good idea to get feedback from the different stakeholders. Having said that, what is interesting is to see that I was participating in a conference on biometrics. It was the USA and EU, yes. And what the European researchers said, they are happy that they have a legal framework because it can boost their innovation. So they are looking for compliant solution. And maybe that's what we should do as well, to write about these compliant solutions. And it will make a huge difference with other markets.
Thank you. I just want to make one final remark, which is that the Article 29 Working Party already called attention to soft biometrics in 2012. And we're still here, so let's all keep working on this. Thank you to the panel, and thank you to the audience.